I'm going to turn it over to Barbara Moskowitz. She is our Associate Director of Caregiver Support within the Dementia Care Collaborative. So let me spotlight Barbara and turn
Thank
it
you,
over.
Nori. And in addition to Nori, my other colleague here tonight is Chris White, and he is our clinical social worker. So welcome all of you. You know, today I couldn't help but notice the headline in the newspaper that today is the day we're emerging from 462-day state of emergency. It's a number, but it's a big number. And I know all of us and all of you feel it in very many different ways. I think last 15 months is a time that frankly is immeasurable, as well as in many ways indescribable. And we in the Dementia Care Support Program really do understand that people with dementia and their caregivers have had a uniquely difficult and challenging year. If you've had challenges of isolation or getting care for the person with dementia, I think there's a whole other story to tell, which we respect. And we're delighted, really delighted that you're here with us tonight. Just want you to know that as we go forward into some reentry, our programs, these seminars are going to remain virtual for at least until the end of 2021 and possibly longer. And as our pleasure has been that many people who couldn't otherwise come have been joining us. So I just want a few words about our program, and then Steve, and he'll begin. As I know you know, because you've heard us say every month, but it doesn't get old to us, the Caregiver Support Program of the Dementia Care Collaborative was started at Mass General in 2017, and we're part of the Division of Palliative Care and Geriatric Medicine. And as many of you know, our mission is to transform memory care. And we exist at Mass General to educate, to support, and to connect clinicians with the community, patients, and caregivers. We offer care consultations to caregivers and patients in specific Mass General clinics, skills classes for caregivers, support groups, and health and resiliency programming. And if you have any questions about any of that, just write to Nori or check our website if you don't yet have that. We've got lots going on. And the Caregiver Support Program is entirely funded through philanthropy. And if you're interested in learning how to support our program, please feel free to contact any one of us and we'll be happy to help you. And now it is my great honor to introduce Stephen Cohen. I just got to say one thing. Last year, 15 months ago, Steve was our very first virtual presenter. I had never heard of Zoom. We were all hurriedly, transforming our lives, trying to figure out if we could touch our groceries or not, or what. Remember that world? And we said, all right, let's have a Zoom meeting. And Steve was our first speaker. So this is actually a greater privilege. It's sentimental. You are our first, and today the emergency is closed. And we have more to go, but it's always great to see you, Steve, and have you here. Steve is a partner at Rubin and Rudman, and he leads the firm's elder law group. He works on behalf of older and disabled adults, and he's one of Greater Boston's most noted elder attorneys. For over 20 years, Steve has been dedicated to educating professionals in the community on the intricacies of elder law. He's been named a Massachusetts Super Attorney by Boston Magazine in the elder law category every year since 2006. And he really is a super attorney. I had to say that, Steve. Steve received his undergraduate degree cum laude from Brandeis and law degree from Boston University School of Law. He's co-author of the Nursing Home Medicaid Eligibility Chapter in Estate Planning for the Aged and Incapacitated Client in Massachusetts, which was published by the Massachusetts Continuing Legal Education. For those of you who have either already applied for Medicaid or Mass Health or expect you might need to, There's no doubt and no question of the intricacies of the law. And that's why we're so privileged to know Steve, among many reasons. He speaks regularly before senior and professional groups, including the Boston Tax Institute, Massachusetts Continuing Legal Education, Harvard Medical School, as well as to healthcare professionals in hospitals and nursing homes. And that's where I first heard Steve over the years. He's married with 2 daughters. He loves to hike in the White Mountains with his dog, bike to work, and dig around in his garden. And I just need to end with one comment. As talented and skilled and recognized he is as a lawyer, what's very unique is Steve is compassionate and understands the life challenges that clients and caregivers bring to him. And that's a very unique combination. So welcome, Steve. It's great to have you here.
Thank you, Barbara. I'm afraid to say anything because after that, I feel like it's only going to be downhill. But that said, I will try. I'm very happy to be here. Is my screen shared now? Let's see.
Not yet.
Okay. How about now?
Yes.
Okay.
Can
Great.
Steve, can you make the view? Oh,
How's that?
nope. Now we cannot see your PowerPoint. Now we see your desktop.
How's that?
Beautiful.
Okay.
Perfect.
I wonder if I can, I'd like to have it on this screen. So if I do it on this screen, you still see my desktop?
Correct.
I wonder if how about if I do that?
Nope.
All right, I will have it on the other screen. The only thing that I won't be always looking at you guys, but
That's okay.
that's all right. So thanks again for having me. It's a pleasure to be with you guys this evening, and thanks for joining us. I'm going to be talking about estate planning, peace of mind for you and your family. As an elder law attorney, I've worked with many caregivers of family and friends who have dementia or some kind of cognitive impairment. And I know that it can be stressful and overwhelming, and especially when considering legal issues or financial issues, it can be very difficult to address. And so I wanted to start with kind of peaceful image as we're going through this, and for us to keep in mind, and in seriousness to remember, don't panic. There are things that you can do, even if you've never done anything with your estate plan. There are always things that you can do to make things better, and it's important not to ignore these issues and to really address it and to be thinking about it. So for the first steps, we've already said don't panic. In addition, when working with an attorney, typically the first thing we do is gathering information. It's important to have all of this together in one place so that when you're making decisions about who's going to help you, they know your situation, your financial summary, your existing legal documents. Those are all things that an attorney is going to want to go over with you. Next is thinking about who's on your team, who are the professionals and family support who you're going to turn to help you as you go through this process and you address the issues you're facing. So that, we start with family, but it's also financial planner, perhaps an elder law attorney, an accountant. Often families, when they're facing elder law issues, work with a professional called a life care manager. These are typically social workers. And Mass General has a great staff of care managers who can advise on more of the human issues and family dynamics surrounding caregiving and dementia. And it's really, often if someone calls me as the first person, their entree into this world, I'm often recommending you really need to speak with a care manager. That's going to be the professional who's going to be critical as you go down this path. So let's think about, what's the legal toolkit that I might use or another elder law attorney might use in working with a client. It's going to include these documents that I've listed here: durable power of attorney, healthcare proxy, medical directives, guardianship possibly, a will. It's important to understand what probate is, trusts, and I'm going to talk also a little bit tonight about a care committee agreement. So this list isn't meant to, these aren't the documents everyone needs, but they're things we go through with clients and discuss, and to try to figure out really on an individual, on a family basis, what's going to be helpful to help this client and their family address the issues they're facing. So I do want to, sometimes people think my next door neighbor has a trust and he can't believe that I don't have a trust. I need to have a trust. I should have had a trust years ago. And that might be true, but it might not. So don't listen to other people necessarily just because what they have might not be appropriate for you. So let's start and talk about documents we call advanced directives. And we call these advanced directives in part because you're giving direction to other people as to decisions they're going to make on your behalf in the future. So durable power of attorney, healthcare proxies, and medical directive. Let's start with a durable power of attorney. So what is this thing? Many people have heard of it. A durable power of attorney is a document where you're naming an agent to make financial and legal decisions on your behalf. So if you name someone as your power of attorney, they can literally sign your name for you, whether that's paying a bill or signing a tax return or signing a deed to a house, anything that you could do for yourself. The power of attorney allows someone to do it for you, specifically in relation to the financial world. It's critical that the document be durable. And what I mean by that is, under the law, the document has to say specifically that it remains in effect regardless of future incapacity. And if it doesn't actually say that, it will stop working just when you need it. So any lawyer who is going to write a power of attorney is going to include that language. It's more of a risk, I find. Sometimes if a client gets a document online, it might not be the right one. So you just have to be sure that it says it's durable. There are two other kinds of powers of attorney: immediate and springing. Immediate, it's what it sounds like. It's effective immediately upon it being signed. Now that can sound frightening to some people. They don't want to give up control before they have to. But when I signed my power of attorney appointing my wife as my agent, it was effective on that date. However, the understanding is that the person you're appointing should not be doing anything unless either you've directed them to do it or they reasonably believe that your capacity has declined to the point where they have to step into that role. A springing power of attorney springs into effect when a contingency occurs. Typically, the contingency is described as a doctor in writing stating that the person lacks capacity to make financial decisions. And when you think about it, that sounds perfect because it's a little bit more explicit about when it's going to be used. But I rarely use springing powers of attorney because on a practical level, they can really be problematic in terms of my clients having problems when they're going to a bank or other financial institution. So I really prefer an immediate power of attorney. Power of attorney, it will last the rest of your life. It stops being effective on death. So at that point, you're not allowed to use it. Again, from a practical perspective, I usually like my clients to re-sign their powers of attorney perhaps every 5-7 years. The older they get, sometimes banks view them as being stale, so to speak. So it's a good idea, even though it's not legally required, to re-sign them every so often. Obviously, when you're dealing in the world of cognitive decline, a day is going to come when that's no longer possible. You have to have enough understanding of what you're signing to sign the documents, and that's fine. But while someone still has capacity, I do recommend re-signing it every so often. So who do you appoint? It's an important conversation that you'll have with your attorney, and not one to take lightly. So in some ways it should be obvious, but it's really not to everyone. I have many clients who assume, oh, it's got to be my oldest child, or it should be my son, without really thinking about whether that person's appropriate. By appropriate, I mean you can trust them completely. They would never do anything inappropriate, never use the money for themselves, only use it for you. In addition, can they manage their own financial affairs? If your son's financial life is a mess, you've always known it, he's had 3 bankruptcies, or he bounces checks, or he's a lovely person, but he's the most disorganized person you've ever seen, why would you hand over your financial world to that person? So you need to really take a hard look, even at family members, to think if they're the right person. And lastly, that they just have common sense, that if they don't know something, they'll either figure it out or they'll hire someone who can advise them on what to do. You can name more than one person at a time. My preference, though, again, based on practicality, is to name one person and then a successor. I find if you name multiple people, some banks want everyone to show up. And that, especially in this day and age, that can just really be difficult. If you're going to name people, if you're 85 and you're naming your 87-year-old husband and your 84-year-old sister, I guess the question is, have you really effectively named a successor? You're all aging at the same time. So a successor should hopefully be younger if that's possible. It isn't always, but it's something to keep in mind. The agent doesn't have any personal liability as long as they're doing what they're supposed to. And again, you want to include a broad range of powers so it's really clear that they can do whatever they need to do. You don't, if I wasn't clear on this point, you don't need to have a lawyer to write this document or any of these documents, as a matter of fact, but typically working with a lawyer is a good idea because of the conversation the lawyer has had with many clients and how he or she can help you think this through for yourself. So the document is being tailored properly for your own needs. Healthcare proxy. So this might be a little bit more familiar to people. Anyone, if you've been hospitalized and they gave you a stack of paper to sign, somewhere in there was a healthcare proxy. This is a document, again, you're appointing an agent, but here you're appointing a medical decision maker, unlike the power of attorney, which is about finances. So with a healthcare proxy, you're appointing an agent to make medical decisions, but they only become empowered to make decisions for you if your primary care physician in writing says you lack capacity to make medical decisions. So it's only effective at that point. In choosing a proxy, it's a different skill set than a power of attorney. So it could be the same person, but doesn't have to. It doesn't have to be. But it's someone who can advocate on your behalf, who has similar values or has values that wouldn't preclude them from following your wishes. And then also someone who can really manage complex medical system that we have. So people often think of it just in terms of end of life decisions, but it may be more coordinating among caregivers and other medical providers to make sure that you're getting the care that you need. The person can make any and all medical decisions on your behalf. I usually recommend you give a copy of the signed proxy to your doctor or other care providers so that they know in the event something happened that you are the person to call. Again, you want to make sure you have a successor. You can't in Massachusetts under the healthcare proxy statute doesn't really contemplate multiple agents. So you're going to name one person at a time with a successor. And if I didn't say this before, on all of these documents, when you're appointing someone, naming them to fill a role in the document, it's important to ask that person, are they available? Would they be willing to do this? You shouldn't assume and just put down the name, because just because you put them down doesn't mean they have to do it. So it's really important to have an honest and open conversation about whether they can realistically fulfill this for you. I also have my clients sign a separate Hipaa authorization, which is a medical release form, because medical providers often want to see that broken out. So even though a proxy has authority to see your medical records, it's important to have it separately. And in addition, you may have people who you want to include on your Hipaa release who aren't your decision makers. So it may be that you have a child, you're not married, and you have a few friends, and you don't want your friends to have to go through the child for the medical information. So perhaps you also give them a Hipaa authorization. So you can have additional people on the Hipaa than the healthcare proxy. Finally, in planning for incapacity, it's important to have a medical directive. So my preference when I'm writing up a healthcare proxy is I build that into the document. So as part of the healthcare proxy document, there's a section, medical directive. And here we capture language in the broadest strokes as to how the client would like decisions made on their behalf if they're incapacitated. A lot of that relates to end of life decisions and whether a client does not want to have intrusive procedures if there's no quality of life. I've also expanded my medical directive so that my client is considering what type of care they would or wouldn't want if they had advanced dementia. So some people, if they had very advanced Alzheimer's or other dementia, would not want to have intrusive medical procedures. If their heart stopped, they wouldn't want to be resuscitated, they wouldn't want to be intubated, and that's all important to have in writing. So it's not just about necessarily having a terminal illness, but it can be whatever you like. It's also another way of handling a medical directive is to have a separate document called a living will. And again, it's capturing your wishes regarding what treatment you want or you don't want in different situations. And they're both important documents that you have in addition and to go along with the important conversations that you have with your clients, with your family rather. In Massachusetts, we also, in addition, have something called an order for life-sustaining treatment. It's called a MOLST, is the acronym. And this is similar to a DNR or a DNH, but it's in the form of a doctor's, physician's medical order. And so if you are sure you want that, it's something to speak to your physician about. It can be very helpful in making sure that your wishes are respected. I think between another thing to just mention between the healthcare proxy and the living will, the proxy is really the primary document. The proxy is recognized by law in Massachusetts. The living will is really just either it's just a directive to your agent. This is what I want you to do, even though I trust you to make decisions. This is guidance to you. It's also a statement for care providers that they can make sure your agent is doing what you want. But otherwise, it only really has it only has legal relevance if there was a lawsuit about end of life decisions. So that rarely happens. And that's why the first document you really want to have is the healthcare proxy, and the living will or medical directive just complements that. So what happens if you don't have a power of attorney or healthcare proxy? So, these are relatively simple documents to get in place. And even if you have a diagnosis, you still can sign these documents as long as you have capacity and have enough understanding. But if someone just never got around to it, then the only way that someone else can step in and make medical or financial decisions on their behalf is by going to court and asking a judge to appoint them as their legal guardian or conservator. A big reason to have the documents is to avoid this. You never want to go to court unless you absolutely have to, both in terms of expense and privacy. And also, a court is often a place where, when there's a disagreement, when you don't have clarity on what your wishes are, people can disagree and substitute their own judgment as to what they think you wanted. So if you haven't made it clear who your power of attorney or healthcare proxy is, perhaps people are going to disagree, and that ends up just being a mess. But in some instances, even if you have a power of attorney or healthcare proxy, it's necessary to go to court. So I've had many cases where, those documents are in place, but the client is, it's a self-neglect case. They're refusing care and treatment. They're not allowing caregivers in the house. They're very paranoid and agitated. And in those situations, despite our best planning, you sometimes have to go to court. So you're hiring a lawyer, and you are filing this legal action, providing medical evidence to the court as to why this is necessary, the degree of impairment, and then also who is the best person to serve. And in this legal proceeding, you have to give notice to the incapacitated person, notice to interested parties. During COVID, it's taking forever to get these cases heard. Unless there's an emergency, it can take 6 months. So we try to plan to avoid for this, but sometimes it is the best thing. And the other advantage, despite all the negatives I was just describing, if you do have a guardian or conservator, that person has ongoing reporting requirements to the court. So the court is looking over their shoulder to make sure they're doing a good job. The downside to just the simple plan, the power of attorney and healthcare proxy, even though they're simple to use, there's not the same kind of oversight. And that's why I really emphasize the level of trust you need to have to make sure that the person will act appropriately. Let's talk about estate planning, sort of basic documents that people should have. Wills and trusts. And it's not everyone needs a trust or necessarily a will, but often it's a really critical part of an estate plan. So let's talk first about a last will and testament. So a will, simply put, it describes who receives your property at death. I'm surprised, I shouldn't say I'm surprised, many people are confused, but a will having a will doesn't mean you avoid having to deal with the courts and avoiding probate. I'll talk about probate a little more. But a will is your personal statement as to what you want to have happen to your property when you die. A will only governs assets that you hold in your sole name when you die. So if I have a will leaving everything to my beloved friend Barbara, but I have a life insurance policy that names my good friend Nori as the beneficiary, Nori is going to get that life insurance despite what my will says. So it's important when you're writing a will to talk with clients and coordinate with them how their assets are held, because otherwise you can end up with a result that is not what you wanted. So it's important to sort of take a holistic view of all of this and to discuss everything. So, it's sometimes I feel a little, when I first started practicing, I felt like I was asking clients a lot of very personal things. And sometimes you'd get a reaction that people really felt that this was private, but without all of that information about your assets, you can't really craft the will that someone needs. If you don't have a will, the good news is, as well as the bad news, that the Commonwealth of Massachusetts has a will for you. And that is called the Law of Intestine. So if you die without a will, there is a law that says who takes what you have. And it's based on how close they are as a family member. So if you're married, it would go to your spouse. If you aren't married and have kids, it all goes to your kids and so on. But that law doesn't necessarily match what you want. So that's why it's important to have a will. In the will, you're also choosing someone who's called a personal representative, and that's the title we use now for what used to be called an executor. That's the person who's in charge of the whole thing. You also can name a legal guardian for minor children or for a disabled spouse, or an adult disabled child, and that person will have priority as far as the court is concerned if your spouse or child needs a guardian or conservator. A will is also a place that you can think about protecting an impaired family member in terms of how you leave them those assets. So probate. So what I was sort of started to get into when I talked about a will is, if I have a will leaving everything to my pals, Barbara and Nori, and they won't get those assets automatically when I die, because in order for the will to be authenticated and for the personal representative to be appointed, you have to file the will in court. And that process of filing the will and asking a judge to authenticate the will and a judge to appoint the personal representative, that is probate. So just having a will doesn't do the job. So if you die, or if a family member who's died and they own things just in their name with no beneficiary, no joint owner, then you have to probate the will. And if no one objects and says that's a bad will, or objects that person shouldn't be personal representative, it can take, well, to at least get the person appointed is going to take 6 months. The whole probate process can be over a year. So a lot of the planning we try to do is to avoid having to probate the estate. And I'll talk about that in a minute when I talk about trusts. When the personal representative is appointed, their job is to find all the assets, make sure they're safe, pay the bills, and then eventually distribute all of the estate to the named heirs under the will. It's, although there's a lot of planning that's done to avoid probate, it's not the end of the world. It takes some time and there are costs associated with it. But it doesn't mean you pay extra taxes. There aren't other penalties. It's just, you have to work through this bureaucracy. And if you can avoid that, that's great. Trusts. So there are lots of different kinds of trusts, and they're used for different purposes. But a trust, basically, it's a kind of a legal entity that can own property. So, we're familiar with corporations or with partnerships. Those are other kinds of legal entities that own things. And a trust is just another one of those. Um, the person who's in charge of the trust is called the trustee. The person who creates it is called either the settlor or the grantor. And the people who benefit from the trust are called the beneficiaries. People sometimes use trusts to avoid probate, as an example. So if while you're alive, you create a trust and you put all your assets into the trust, which, for example, if I have a bank account in my name, it says Steve Cohen on the statement. If I've created the Steve Cohen Revocable Trust, it's just a matter of my going to the bank and opening a new account in the name of the Steve Cohen Revocable Trust. And then if everything I owned was in my trust and it said everything goes to my pals Barbara and Nori, then they don't have to deal with probate. It would just automatically go to them. The person you're naming as the trustee has to follow the rules of the trust. You could be trustee of your own trust. A trust could be revocable, which, as it sounds, you can change it and you can revoke it, you can amend it, or irrevocable. You can't change it after you've created it. And again, just because someone has a trust, that doesn't mean that you need one or that the trust they have is the right one for you. If someone calls me and says, Steve, I want you to write a trust, my job is to figure out, well, what is the problem this person is facing, or what's their area of concern? And is a trust the right document that's going to address that for them? And maybe it is. Maybe they're worried about probate. Maybe they're wealthy and they want to minimize estate taxes. Maybe they want to protect some of their assets from their long-term care costs. Those are all different kinds of trusts. Maybe they want to take care of their beloved pets when they die. I have clients that want to do that. Those can all be accomplished with trusts. Or they might have a child who is vulnerable because of disability or substance abuse or lack of sophistication regarding money. And the worst thing would be for that person to get an inheritance directly. So the client's worried about looking out for this child or other person. So instead of leaving it to that person directly, we leave it into a trust. And the trust will be a vehicle to hold those funds on behalf of that person who is vulnerable. So we also, in this area with worried about long-term care, we can include language that directs the trustee to use the money to maintain independence so the person can stay in their home or the most home-like situation possible, to foster their relationships with their family, friends, community. You really can tailor this to whatever you want. And especially, I have increasing numbers of clients who are not partnered, who don't have children. And so they may not have people as they age who they can rely on to use their funds in a way that's going to allow them to age well. And a trust can be an important part of a plan for someone in that situation. The last thing on here, again, it can really protect someone who's vulnerable from financial predators. And, actually, speaking of that, this past year, there's always, unfortunately, we all are well aware of that elder abuse has become endemic. And even worse this past year, where so many elders have been isolated and not been not seeing their family. And lots of this types of financial scams come through our computers and over the phone. And it's important, a trust can be one vehicle to separate someone from their assets so they can't give it away to someone over the phone. There are other practical steps you can take, but it's, this year it's really hit home how vulnerable elders can be in that kind of a situation. Another document I want to discuss is a care committee agreement. So this is I've found to be particularly helpful. As I mentioned, there are more people living who don't have kids or whose kids are not close by, and they may be asking friends or family members who aren't living as close by to take on important roles. And when you describe to people what it really means to be a healthcare proxy or a power of attorney, you realize it's a big responsibility. If someone's really going to think about what that could mean, they shouldn't be taking it lightly. And I have some clients who are hesitant to ask a friend or a niece to do this for them because they don't, none of us want to be a burden. And perhaps the niece or friend wouldn't consider it to be that. But the idea of a care committee is to identify the people around you, family, friends, and professionals who are your support network, your team, and to formalize these connections and relationships so that while you still have capacity, these people know who each other are, they are communicating together, and they are all meeting with you and discussing on some regular kind of a basis what your wishes are to help in supported decision making so that the client ages well and ages as they want. So and within this care committee, a very important professional I usually recommend is to include a care manager who can help facilitate the discussions and be the objective professional to advise about care needs over time. And it really, I've seen it work beautifully for clients and their friends and family, giving the client and the healthcare agent and family peace of mind that in a crisis or when the person really completely loses capacity, that it's not going to fall, the responsibilities won't fall completely on one person. And there are other people connected who responsibilities can be delegated to, who can help support the agents in making difficult decisions over time. So again, not for everyone, but it can be very helpful. And also, I've seen the care committee work in conjunction with the trustee of a trust to advise the trustee how should they use the money in the trust to support the client's wishes regarding how they want to age and what kind of care they want to receive. So lastly, just to talk a little bit about financial planning in this area. So for someone who has a family member with dementia, it can be very frightening thinking about what the care costs might be over time, whether that's for home care or assisted living or nursing home care. It really can add up to a lot. I mean, nursing homes in Massachusetts now can average between $15,000 to almost $20,000 a month. And so even for people who have saved and have accumulated some wealth, that kind of cost can be overwhelming. For younger people in thinking about this, I talked to them about possibly buying long-term care insurance, which is a kind of insurance that will pay for home care, assisted living, or nursing home. But you really can only buy that if, well, first of all, you have to be able to afford it. It's not inexpensive, and you have to have had the foresight to do it, to purchase it when you're well and you're young enough. So someone in their 50s who's in good health, it's very affordable. Someone in their 80s would not be able to get it. Someone who has a diagnosis of some type of care that's going to result in a cognitive decline is not going to be able to get it. Medicare, it can be a great program, but it pays for very little long-term care costs. Sometimes it pays for nothing, depending on the situation. Otherwise, you can pay privately, and if you're fortunate that you have a lot of money, you'll have a better, well, you have more choices, I guess, is the bottom line. And that, unfortunately, is a general truth about our healthcare system. How much money you have does impact what care you can access. Many of my clients plan for the possibility that they might need nursing home care, and they plan for the possibility of becoming eligible for Mass Health. So Mass Health is our state's Medicaid program, and it will pay completely for nursing home care if you're eligible. But as Barbara said in the beginning, the rules here are really complex. There are many traps for the unwary, and it's very easy to make mistakes. So it's a great program, and you could be in the same nursing home that costs $200,000 a year, and Mass Health will pay for it. But to be eligible, you've got to meet their financial criteria. So you have to show that your assets are below the limits that they set. And in addition, you've got to show you haven't given away any assets in the last 5 years. So if that's something that you're considering, if you don't have enough money to really be able to afford to pay privately without impacting your financial security, it's important to talk with an elder law attorney sooner rather than later to see if, to review your finances and to see if it makes sense at all to do any Mass Health planning. It's not for everyone, but it's one of those things. Timing is a factor, and it's better to do it sooner rather than later. So just to kind of sum up, in conclusion about all this, I think, from a lawyer's perspective, one of the most important things I want my clients to do is to communicate with their family. People often, there are reasons sometimes to be private or not share everything, but people need to know who the decision makers are and what their responsibilities are. I can't tell you, I also have lots of clients who are in their 40s and 50s, and they say, you know what, I really don't know who my father's power of attorney is. He's never talked about it. And so these conversations are critical. If you really want your wishes to be respected, you have to share and communicate about this. Getting organized. I can't tell you, so many times I have a client and their parent had a stroke or something sudden happened, and no one knows where anything is. It's never been discussed. They don't know where the bank accounts are. They don't know what the bills are. They don't know any of the passwords. And you all know, how difficult it is, just the fact of addressing someone's illness. To add on top of it, chaos is terrible. So to the more that you get organized, it's a gift you're giving to the people who you're asking to help you. And your lawyer can help you in that process and getting organized. Gathering your team. So you want to make sure that you have all your professionals in place. They know each other, or they know who each other are, rather, and that the agents who you've appointed under your proxy and your power of attorney, your trustee, they know who your professionals are, and they know how to contact them. Make sure your financial and legal paperwork and care plans are updated. You know, these are documents, people often, they get it done and they stick it in a drawer and it doesn't get taken out till 25 years later. Fingers crossed, it's still good. And when I say good, I mean life, it takes all kinds of curves and different paths. And with life's changes, a document you made 25 years ago might not make sense anymore. So these are organic documents, and I think they need to be reviewed as life goes along. So perhaps every 5-10 years, depending on how old you are, you want to talk to your lawyer and make sure that your documents are up to date. And then lastly, follow through. So I have lots of clients who get started and they never finish. So it's important, once you break the inertia to do this, you get it done. And you share finally, when the documents are signed, you share them with your doctor, your healthcare agent, your power of attorney, so that people in an emergency, they have the documents they need to step up and do what they need on your behalf. So that's about it. Again, I want to thank you for joining. I think we have some time. I don't know if any questions came through, but if they did, I'm happy to stick around for a little bit and see if I can answer them.
I have a couple of questions, Steve,
Great.
and while I'm asking, please feel free. Could you take your slides down now so we could just have a gallery view, perhaps? Excellent, great. Okay. Well, if anyone wants, please write your questions. Steve, one thing, you mentioned a Hipaa release form, which of course makes sense and is important, but where does one get that? I mean, do I go to the hospital to get it? Where do I get it?
Usually any medical provider, your doctor's office is going to have that, or the hospital would have it. I haven't really looked online, but I'm sure you could get a simple form online as well. Or, if I'm working with a client, I have my form that I use, but typically the place to start would be your doctor's office.
Okay, that helps me know that I'm going to check over at Mass General. And I have another, from your program, something when you said very clearly that when I appointed an agent, when you have a durable power of attorney and you appoint an agent, I think you said an agent has no liability. And I just want to give you a quick example that just 2 weeks ago, I spoke to a family member about, and perhaps you can clarify, because the institution where the son was signing his father into, and he was the durable power of attorney, gave him a big document to sign, right? Because it was going to be private pay. And the way the document seemed to be worded so that the son felt afraid was they kept saying to him language like, well, you need to sign this as a durable power of attorney, you're responsible. And he'd say, I'm responsible. No. So it was a little bit of a lot of things. And so if you could clarify. So what I said, tell me if I was close. I said, what I've learned is that the money will not come out. When you're responsible as a designated power of attorney to manage payment, but it's payment with the patient's money, not your own. But he was feeling, and of course, when you're doing this in crisis, you get nervous. But
Absolutely.
The executive director was sort of making this man feel that he was going to be liable for his father's bill. Can you comment?
Yeah, I'm so glad you asked that, because one thing I didn't really clarify well is that, that is very frightening. You're signing this contract and everyone wants to know, I'm not personally responsible. So the way you clarify that is whenever you're signing as a power of attorney, you're signing, you're not going to just sign your personal name. So Barbara, if you were my power of attorney, and you were signing that admission agreement to the facility, you would not sign that Barbara Moskowitz. If you did, then you could be personally responsible. You would sign it Stephen Cohen by Barbara Moskowitz as power of attorney or something to that effect.
Oh, that's new for me. Thank you.
Whenever so it's always important to the outside world when a power of attorney is signing something, who's really signing and in what capacity. So you always, even if you wrote Barbara Moskowitz POA, that would be okay.
Got it.
So that's the important piece, is you're not personally responsible as long as you've made clear how you're signing it.
Oh, that's absolutely so important.
Yeah, no, thanks again for asking that.
I got a few more, but first, Nancy is asking, is the hospital healthcare proxy form fairly standard and sufficient? Do you want to
Yeah, I
answer
think
that?
it is. And if you don't want to see a lawyer, you don't want to spend the money, the hospital form would be fine. Most of my clients, so if someone called me and said, I only need a healthcare proxy, I would probably say, you know what, call your doctor or call the hospital, you can get that form there. But, you know, I have a little bit of a preference for my form, but I think the standard form, that the state would give you also is fine.
Great, thank you. Here's an important question, and I'll read it in the form of a paragraph. Our mom is the caregiver for our dad, who has severe dementia, and they have had an irrevocable trust for the last 5 years. They currently, I just lost it, right. They currently live in their own home. A change is coming as the needs are increasing. So here's the question. Does it make sense for them to buy or rent a condo given the 5-year look back? That's a lot to unpack.
I'm not sure I completely understand the question. So,
yeah,
but people often put their home, they put assets in an irrevocable trust. When you're applying for Mass Health, they can look back over all your records for 5 years. That's called the look back period. And you don't want to apply until 5 years have passed. I'm not sure about how that relates to buying or renting a condo. So unfortunately, that, you know, in that kind of a situation, you really need to, that's not something a lawyer could, you know, answer simply. It's a complex question. It's a perfect example of, you could never call someone up and talk to them for 10 minutes and describe and say, should they do this? Because that's more like an hour or a 2-hour conversation, so that it's the person who's advising you understands the whole context and is really, so I would go back in there. I mean, they must have met with a lawyer who did the trust. I would talk to that lawyer about it.
And Steve, we use a lot of medical analogies since we're in a hospital, and I think perhaps you'd agree that this would be similar to my talking on the phone to my doctor and saying, so I have a bump on my shoulder. Do you think it's cancer? And I do respect, that's the point. Diagnosis essentially is what you're saying has to be done. So I'm going to read this other important question, and it may be something that has this similar response from you. My mom made an irrevocable trust with all of us 3 kids as trustees. My brother is still living in the house since 2011 in New York State. He's ignoring selling the house. So my sister and I can't get our 1/3 of the money from the house. I'm not pushing that he moves, but my sister wants her share. So what do? We don't want a big kerfuffle, I love that word, and upset him, but he won't move. Thanks, Steve.
Yeah, people don't use kerfuffle enough. I'm very pleased
good
to see that word.
Right.
Unfortunately, the only way that's going to happen is a kerfuffle.
Uh-huh.
You would have, I mean, and unfortunately, that's the problem, and that's a good example in a trust. A lawyer perhaps should have asked mom, do you want, after you die, do you want the house to have to be sold? Or do you want to give, since your son's living there, let's lay out what the rules are if one of your children wants to sell. Because if you don't say what the rules are, then that ambiguity is what pushes people to have to go to court. So unfortunately, the two sisters either have to sit back and do nothing, or it's kerfuffle. They've got to hire a lawyer and go to court in New York and force the sale. Whereas the trust could have otherwise be written, it could have said, when I die, my son can live in the house for 1 year. He has to pay all the expenses. After the year, the house must be sold. Or my son has to buy out his sisters at a fair market value, or whatever it is. But without that language, it's going to be messy, unfortunately.
Thank you. I have just one last question. I've experienced that a lot of us are confused about what a most or post is. By the way, if any of you are curious, if you just it's POLST.org. It's a great website. That's the national website. And then every state, like Massachusetts, has put an M in front of the OLST. But the post.org website is fantastic. But Steve, it was on your list. And had I not recently paid really close attention, I might now be confused about, so do I need it? Do I not? What I've been taught, but please, and that's why we work together, is it's only really necessary if I'm caring for my relative at home, maybe in hospice or late stage dementia. And should he or she fall, or should I want to call the EMTs? Without a MOST, which is a doctor's order saying Barbara Moskowitz only wants comfort measures, EMTs are required by their training to attempt to treat me. And I've understood that the MOST is what helps me tell the EMTs, give me comfort, but don't take me to the emergency room.
That's my understanding also, Barbara. But it really, I had an interesting conversation with another care manager, someone at JF and CS. And I have a client who's 80 and she's amazing. She's still working. She's in great health. And she has a MOLST with a DNR. And I was surprised. And because I explained, I said, we were actually, this was during COVID, and we were walking outside for our meeting. And I said, if you had a heart attack right now, I would call an ambulance. Would you not want me to do that? And she was, I'm not really sure. She said, the consequences of being resuscitated frighten me. I don't want to be, I've lived a full life. And she had a long conversation with the care manager, and she came back and said, I really think this is the right thing for me. I don't want to take the chance. I understand that by not being resuscitated, I might, I could be fine and have another 5 years or 10 years. But at this age, I could go down a very different path, and I'm not going to take that chance. So I want the most, because it's the clearest directive to ensure that I don't get care I don't want.
Is it fair for us, for just the purpose of this important talk, to let people know that we all, you, me, Nori, Chris, we all need healthcare proxies? That's regardless of age, regardless of condition. We all need healthcare proxies, and even medical directives. But the POST or MOST is about individuals who are in a late stage of illness. So let us distinguish that for you.
Well, I would say I absolutely agree with you. I'll need healthcare proxies, but my takeaway from this recent experience is that it's not just about late stage illness. It could
All
be
right.
late stage of life. It could be a vital 90-year-old
Okay.
wants to, so, but I think it's not for everyone.
All right. But it's not something that, as you're telling me to get my papers in order,
No,
it's not something that I do now.
correct.
It's something that if I'm dealing with a certain phase of life and illnesses. Okay.
Absolutely, yes.
And here's a good question, Steve. Could you go over how an agent should sign forms for a disabled incompetent person under a POA? Oh, you just told me, but redo that. So could you go over how an
Well, yeah, so
agent signs
if
forms?
Barbara is my power of attorney, she would sign, and she needed to sign something for me, whether it was a check or a contract. She would sign my name, Stephen Cohen. And the formal way to do it is Stephen Cohen by Barbara Moskowitz as power of attorney. People sometimes, when I have a couple of clients who I'm power of attorney for, and if I'm signing 10 checks, I write Stephen Cohen POA. If I really am doing a lot of it, and that's okay too. So there isn't if it was a very important document, I would sign it the lengthier way as I just described.
Terrific. And I think we have one last long, question, which again may be in need of further analysis, but I'm going to read it to you. I have a partially funded special needs trust, and I have assets that are not in the trust. I'm not sure if I should add assets to the trust or leave them out, and I'm not sure if I should have the trust at all. Some people have said it's a very complicated vehicle and it may cause more problems than it solves, and that's my question.
Well, the part of it that the piece of information I don't have is whether this person funded the supplemental needs trust for themselves, or they are funding it for another person after they die, or if someone else funded it for them. So I'm going to assume that this is a trust that they are funding that will benefit someone else after they die. And it really, whether my personal preference is not to fund it now. I like to fund it unless the person really needs the money. It would be funded either through my will or perhaps by an umbrella trust. So I might have an estate plan that has a trust for me, and it says when I die, everything goes to my 3 children in equal shares, but my daughter Jane, her share goes to her supplemental needs trust. So it's hard to say whether to
Sure.
fund it now or not makes sense.
This person, last comment, this person added, someone else funded it for me. I'm in housing choice home ownership voucher.
So if someone else, that's an important piece of information. Supplemental needs trust rules are very different when it's funded by someone else. So if a parent funds a supplemental needs trust for someone, that kind of a trust has a lot of protection. And you never want to take your own money and put it into that trust. It would be messing up the trust. So you want to, a trust funded by someone else is called a third party trust. A trust funded by the individual is called a self-funded trust, and you never want to mix up those monies. That's
all right. And so he speaks. As I've been sitting here, I think we're going to wrap up now. If there's any other question right now, or yes, Nori.
Just one question. Some folks asked if you would share the slides. Do you give permission for me to email them to folks? And you can say no.
absolutely.
Yeah. Okay.
Absolutely. As
So
long as people promise to use the word kerfuffle sometime in the next few weeks.
There you go.
All right.
There you go.
All right.
And it's a great way to end with a smile. I was just thinking that tonight's important talk reinforced what I've learned over the years is that I know what I don't know. And I think that's a gift. I mean, I know that I'm not a doctor. I can't talk to people about medication. And I sure as heck know that I don't know the intricacies of elder law. And that is why we are so lucky that we know you and we have your expertise. So thank you, Steve, and thank you for continuing to teach us and be available to us. And to our audience, before you sign off, we wish you a lovely night. And next month, on July 15th, we are having a program with Sandy Saversky. She's the founding director of the Elderwise Way, Spirit-Centered Care. And actually, Nori knows her, and Nori has promised our team she will be inspiring.
Well, I've read her book and I've spoken with her, and it was really a wonderful lens of looking. So if you pick up the book, Elderwise Way, Spirit-Centered Care, and if not, just come to our program next month.
Great. So be well, everyone. Thank you, Steve. We know we'll see you back here next year. We don't know if it will be Zoom or with brownies and cookies in O'Keefe, but one way or the other, this is your invitation.
I'll be here.
Thank you.